listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law with Kyla Lee. I'm not Kyla Lee because Kyla is so busy that she didn't have time to record the podcast this week, but I have Alice with me. Alice has been on the podcast before, a friend of the podcast.
Yes, and definitely not Kyla Lee either. But I'm here, and we're going to get through the podcast episode together.
You have some attributes of Kyla, though. You're very clever, very smart, and fast on your feet. Alice is an articled student, but has completed basically everything, and we're now at the point where it's the time for the petition to call, and soon she'll be a lawyer, and can't wait for her to be a lawyer because she's going to be a great lawyer. She's been a fantastic student and been with us as a student through law school as well. So long history and connection with acumen law. Alice has been one of those reliable people that we can count on. And count on here today to be a podcast guest and a good one, because I suspect your analysis of the law is better than mine. We have a couple of things to talk about. The first one is a decision that came out just this week from BC Supreme Court. It's an appellate decision. Rex and Ronald Andrew Fast.
Bit of an ironic name, really.
Yeah, ironic name, and not one that you necessarily want to have when you are charged with impaired driving and impaired driving causing bodily harm as a result of an accident. So what happens here? Well, I should say why it's interesting, actually, to start with, because back in 2018, the law was changed. December 18th, 2018, a bunch of changes came into effect with the criminal code. And one of them was with respect to causation in impaired driving cases where bodily harm is caused. And it used to suggest that your impairment led to you driving badly, which led to the accident, which led to somebody being harmed. And that was the causation part. And so if you were, for example, impaired and you were rear-ended, you could, the Crown could not prove the bodily harm, of course, to the person who rear-ended you or your passenger or whoever. When they changed the code, we were looking at it and it looked to us like you could be responsible no matter what if you were impaired. Like you could be stopped dead and hit and you could be responsible. And that partially makes sense to me because you could say to yourself, the Crown can pass any law they want so long as it's constitutional. And what are you doing on the road? I mean, but for you being on the road, there wouldn't be an accident. And I think Kyla and I spoke about this when we presented to Parliament or the Senate or something like this back in 2018. Not really sure anymore. Much is lost to me from 2018 because of head injuries and the trauma that we've all experienced in the time since. But I was concerned about that interpretation of it. Now, in this case, what happened was Mr. Fast is driving along and he is apparently impaired in his ability to drive because he ends up convicted of that, simpliciter. And he's approaching an intersection and there's another vehicle driven by, I think it's Mr. LeBlanc. And Mr. LeBlanc is on the phone and makes a very quick lane change from left to right. And Mr. Fast is in the right lane and rear ends Mr. LeBlanc. And Mr. LeBlanc is, I guess, injured. That must have been by admission or something like that. And it goes to court. It looks like probably Richmond Provincial Court. I'm not really sure. And the judge looks at it and says, okay, well, let's deal with the impairment issue. Impairment ends up being proven. It's a drug impaired. Impairment ends up being proven. And but they've got this video from Mr. LeBlanc's car, the one who's hit. His dash cam video shows that he makes this lane change, leaving Mr. Fast 1 to 2 seconds of time to respond to avoid this collision and to stop. So you're looking at it and you're saying to yourself, there's a bunch of things that come to mind. I don't know what came to mind for you. What did come to mind for you?
Well, I think first of all, in terms of the causation question, I think the return to maybe assessing causation in a different way or in the older way before the 2018 changes, I think it makes more logical sense to me.
Yeah.
Where if the person who's alleged to be impaired or found to be impaired um, is unable, has no way of preventing the accident, I don't think they should be held liable for causing the bodily harm that results from the accident.
Yeah, but I think again, like as I sort of suggested at the outset, maybe they should be permitted to create that if that's what they wanted. But I don't know that that's what they wanted now when I look at the writing in it. But the first thing that came to mind to me was here's a situation. Rarely is an accident from behind something that you are not responsible for. You're almost always responsible for a rear ender, right? And the only reason in the end that he's like not responsible for that collision is because of the dash cam of the guy who made the lane change, who was on the phone, who interestingly wasn't called as a witness. I guess, it may have been by admission that he was injured. But yeah, his dash cam worked against that guy for changing lanes. So dash cams are going to catch your bad driving behavior as well as your good driving behavior and as well as the good or bad driving behavior of other people on the road. That was sort of the first thing that came to my mind. The second thing that came to my mind was, all right, let's deal with this issue of causation and let's take a look at how it's written. So the way it used to be written in the criminal code was everyone who commits an offense under paragraph 253(1)(a), that's impaired driving type offenses, and causes bodily harm to another person as a result is guilty of an indictable offense and liable to imprisonment of more than 10 years. That was the old version of it, and it was the as a result that made sense to me if you want to make it that way. The change was everyone commits an offense who causes everyone who commits an offense who causes an offense under subsection 1 and who, while operating the conveyance, causes bodily harm to another. And it still has a cause in there. So I guess there is still a cause is the point. And so this goes to BC Supreme Court. It might end up going to the Court of Appeal yet, but it goes to BC Supreme Court, and ultimately the judge looks at it and says, well, causation is a factor, and this was an unavoidable accident. It was, unavoidable for the driver who's charged with impaired driving. It was avoidable for the guy who changed lanes with not enough time, not looking in his rearview mirror, not looking to see that there's a car coming, not, which is something many of us do, hoping that that car behind you has enough time to respond. But of course, at an intersection, it was an interesting finding of fact, though, because you think okay, you've got a red light. You got somebody who changes lanes right before the red light. The vehicle that's coming up from behind, surely must have enough, be driving slowly enough and braking enough to be able to stop for the intersection. If it can't stop for the intersection, we're only talking about 3 more meters for a car. You see what I'm saying?
That's true. The judge did say it was a stale red in the footage as well.
So, you would think that he would be maybe going too fast under those circumstances and therefore couldn't stop in the 1 to 2 seconds. Like if you're pulling up to an intersection and it's a stale red, you should be slowing down enough to be able to stop. And if a vehicle in front of you changes lanes into your lane, you should reasonably anticipate that. But in the end, the fault fell to the fellow who changed lanes. And Mr. Fast was not found to have been driving too fast.
Luckily for him. But I guess, as you said, we'll see if this goes any further in the court system. If there are any more appeals.
Yeah, I mean, I suspect it will. This is a quote from that was more or less accepted. The Crown's argument was that there was inconsistencies in the judge's decision um, and that was essentially cherry picking it, that would lead to the conclusion that the judge had considered an inappropriate test for causation. Um, but I mean, I think it had to be some fault was the point. But at paragraph, this one paragraph I highlighted, the law. This is from the trial judge's decision. The law does not provide that if you are impaired and involved in a collision, that you are automatically guilty of impaired driving causing bodily harm. That's what it suggested to me when I read it years ago. It must be proven that impairment was a contributing cause of the collision. Some fault on the part of the driver must be found aside from the fact of impairment alone. So that's where we are. There has to be some causation. And it looked like some contribution of it. And it appeared in this case that the cause of the injury, the cause of the accident was Mr. LeBlanc changing lanes. Anyway, that's an interesting one. It's going to be an interesting one to follow, an interesting one to see where that one goes. We have an update as well on another case that maybe you don't know about. And I haven't read the whole update. I just started flipping through it because it came out today.
Once a law student, always a law student, just flipping through cases, not really knowing what's going on.
Well, that's the thing. That's the thing. While you were were you like the last person to have to do PLTC, or?
There's one more intake starting in May, so in a few weeks' time.
So for anybody who's listening or watching us in British Columbia, we've had the professional legal training course for years, PLTC. That was the bar course, and then you have the bar exam essentially at the end, the PLTC exam, which is a series of exams. And it went online in the pandemic, and we noticed people struggled with it online. The pass rate out of our office wasn't as solid as it had been. But it was the same course, almost identical material to when I did it 27 years ago, like May of 1999. I was in there doing it, and every time I looked at it, I was like, Jesus, nothing changes? Is it that this? But now everything's changing. So
Everything is changing.
what is the new thing that they're going to be doing?
So my understanding is that the delivery of the course will match up with several other provinces, including Manitoba and Alberta. It's run through CPLED, which I think is Continuing Professional Legal Education. The D, I don't really know what it stands for, but it's called PrEP. It will be slightly different, is my understanding. There will be some components where you have a virtual, you're working in a virtual legal practice. You're taking on these mock files. So it seems to be the angle anyway seems to be geared toward maybe more practical learning rather than testing.
Okay. Well, I mean, the assessments were sort of practical learning in PLTC, but they were having problems with that because everybody was using AI to do their assessments, which,
Yeah, I did see the new curriculum for the prep course does have a specific at least a workshop based around use of AI. So I think they're slowly but surely catching up to the trend.
we have no choice. Like it's a tool. It will morph, and in a year it may be completely different, but I think we have no choice but to deal with that. But the problem that they were having was that they couldn't reliably do assessments of people when the assessments were things that you do on your own, and just turn to AI and it can do it better, write a more complete contract than you can. It might not be legally correct. I mean, if you do it that way, but it's going to sound really good and might persuade somebody that it's appropriate and might be right. Like I think contract law is probably the area of the law and a few other areas of the law that are most likely to be affected, and do-it-yourselfers doing it. Which brings me to another issue of AI, actually, that I want to talk about. It's not a driving law thing, but it could be a driving law thing. So there was a fellow in New York State who was investigated for a fairly serious crime. and he hadn't hired a lawyer. What he had done was he had been discussing his defense with some form of AI. I think it might have been Claude, but I'm not sure. And of course, it ends up going to court because of the fact that they did find out about this AI discussion, and they learned that he had it, and of course they managed to get it by a warrant or some other way. And this fellow wanted to claim that there was privilege in the discussion because it was discussing a legal matter, and that the AI was his legal representative. And you can imagine how that went.
Yes, I think New York State now they're potentially looking at implementing into statute that a lawyer, for these purposes anyway, must be human.
Yeah.
Yeah.
Yeah. Yeah. But I mean, the court already basically ruled on it that uh, AI is not a lawyer. There's no privilege. There's no protection. There's no solicitor-client relationship. There's no protection in law for it. So anything you discuss with AI could potentially be evidence used against you. And like that, when you say it, you hear it and you go, well, obviously. But I don't think many people are thinking that. And I don't think many lawyers are even thinking about it. They're looking at their clients sending them these AI things that are terribly long and involved and very often miss the point. And it's 3 pages of AI written gibberish that we get from somebody. But what we should be thinking about is the fact that they're discussing it with that AI, and they are putting themselves at risk for all of that to be disclosed and used against them. And it falls into the new realm of legal advice that you probably have to start advising people. Anything you put on your computer, typing to AI or Google or anywhere, maybe we should have been saying this for years, is not protected. If you're writing to the lawyer, it's protected. But if you're using AI to generate something that you're then going to write to the lawyer, I don't think that's protected at all. It certainly wouldn't be on the basis of that case out of New York.
Hmm. Definitely
But
new waters.
yeah, definitely new waters. And it is I mean, on the one hand, as I said a moment ago, you might be able to write a better contract using AI than you can as a lawyer. I look at contracts. I took contract law, but actually writing contracts, looking at contracts, I look at them and I wonder, why did they put this in this one, like a lease, and why didn't they put it in this one? On what basis is the difference? And what does this really mean? Is this just some holdover, you know, and you have it written by AI, and you're like, well, why didn't it put that in? I don't know all the law and contracts, so there may be reasons that things are in there and not in there, but very often it's like commercial contracts for the same thing that just who knows what the standard is, where they started with their precedent or what have you. And in that realm of law, I can see where AI is going to undermine the practice of law. But then when I look at this case out of New York and the fact that there is no privilege or protection for what you said to your AI, it reminds you that there are very good reasons that you should hire a lawyer, which brings us to the next case I wanted to talk about, which we've talked about before on the podcast. It's Regina Rax, and Dancho, Dancho, Dancho. It's one we talked about before, Kyla and I, and so this is just an update because the decision came out today from the BC Court of Appeal appealing the Supreme Court decision. And this time there is a lawyer involved, but at the earlier level, as I recall, there may not have been. So this fellow had paid his ticket, and or had sought an extension of time for a deemed conviction for something that he had already paid. And he wanted to argue that his guilty plea was uninformed when he found out about the driver point premium, driver risk premium. So in BC, it does feel like a bait and switch. You get a ticket for excessive speeding, for example, it's $368. You're saying to yourself, I can afford $368, and I was going pretty fast, and you go and pay that ticket. It's only 3 points, but it gets on your driving record and it's considered a high-risk offense. It automatically triggers driver risk premium. If you've got any other points on your license, it's going to trigger driver point premium. Those are bills that come to you when your birthday approaches. And it can continue if you get more tickets in another ticket the following year. And so it's fairly significant consequences. Also, driving prohibitions, because the superintendent of motor vehicles obviously looks at an excessive speeding, which is 40 kilometers an hour over the speed limit, as more aggravated than your standard old speeding ticket of maybe 20 kilometers an hour over the speed limit. So when he found out about all of these consequences, he said to himself, I wouldn't have paid this thing had I known about it. Now, this is something that you have covered. You've done lots of research over the last year or so into appeals and things for Kyla. What is your take on it?
I think it's so interesting just how much time has elapsed, first of all, since the original ticket was issued. All of these arguments and the consideration of, let's see, they considered the Palmer test with the four prongs, and I thought it was so interesting that if this evidence had been considered, whether or not it would have impacted the
For
result of the trial.
the
They
new
felt that
evidence motion that he made,
yeah,
and he wasn't successful on in BC
right.
Supreme Court. Yeah.
Mhm.
So what was their take on that? You gave it the good read.
I did give it as much of a read as I could,
Yeah.
but again,
Well,
it did come out today.
you had 10 minutes.
Mhm. He provided an email from ICBC just about the driver premium points system and the record of proceedings. But ultimately, they did find that the judge in the previous instance found that none of this really mattered for the application. So in the end, it didn't matter for Mr. Dancho's application for fresh evidence. Um, so it seemed like it was a very brief review of just the record of proceedings and what was said by the original judge. And poor Mr. Dancho, unfortunately, his appeal has been dismissed.
Yeah, he was not successful, and that's the end of the line. The the one thing that I just remembered from the lower court was that he had done all of this without a lawyer at the start. And there seemed to be avenues that he could have advanced that he didn't. And of course, what people don't understand, and I try to explain it, but it doesn't connect with people, is that appeals are not new hearings. An appeal is looking at the decision of the previous either adjudicator or judge to identify whether or not they made a mistake. And so a lot of people go in self-represented, now using AI, writing their own submissions, thinking if afterward I'm not successful, I will then call a lawyer and try and appeal it. And that was my thoughts when I originally read the BC Supreme Court decision. Obviously, you and I would not have advised him to plead guilty if he had pled guilty. We would have advised the consequences of it. But ultimately, in the end, here the court says, look, there's some things that you are presumed to know. You're presumed to know that there are consequences of the ticket. You can always research it, but you are a driver and you're presumed to know the law. And the consequences of the ticket, those other consequences of the ticket, I was surprised that the focus wasn't more on. The other consequences of the ticket are administrative consequences. And there's always administrative consequences of all sorts of things. I mean, if you're found guilty of impaired driving in BC, you are going to end up sent to the responsible driver program. It's an administrative consequence. If you go in and plead guilty, the judge isn't saying, do you understand, sir, at the end of this, you're going to have to complete the responsible driver program before ICBC is going to issue your license or sign up for it or whatever. These are essentially administrative consequences. It could have just been simply framed that way, but instead it was more or less framed of, you're reasonably expected to know what you're doing when you're paying your traffic ticket or to research it.
Yeah, it's tough. With all of these administrative consequences, especially, it does. I think, feel to many people that the system is quite opaque, that they need
Yeah.
more guidance. And that's something that I'm often very careful of when I'm, speaking to clients in terms of passing on advice from lawyers or just preparing them for court.
When I was a student, it was very common for me to give legal advice, and it was all about things that were like I had some certain knowledge about, but that was just something that you did. But I don't think it's nearly as common anymore for students. We have this tendency now in the process to isolate our students from that, to ensure that we're not in trouble for um, having our students held out giving legal advice, and our students getting in trouble for giving legal advice that they're not authorized to give. And it's kind of unfortunate. Maybe that's a good thing of the new program where they're going to be doing mock scenarios where you're giving mock legal advice all the time. Then one day you're a lawyer and and you're suddenly thrust into doing it. I guess that's just the way it goes.
Mhm.
Anyway, yeah, Mr. Dancho would have benefited from legal advice at the start, and he managed to find someone to go and argue his appeal, and did their best valiantly, and were unsuccessful. And it is uh, uh, could have a bit of a chilling effect, I think, on unwind applications. So sometimes we are applying to have a deemed conviction or a conviction for a traffic ticket lifted because it was merely through the process of law rather than the person rushing in to pay the ticket. There are times that the person has paid the ticket, and I've been able to have the ticket lifted and then put back into dispute. But it's very rare, exceptionally rare circumstances, and I would say after this now it's going to be an almost never happening circumstance. We
Law,
shall
ever changing.
we shall see.
Mhm.
Anyway, time to move on to my favorite part of the podcast, which is the ridiculous driver of the week. And Alice has all the information about the ridiculous driver because I sent it to her and we were talking about it before we started recording. And she had the facts correct and I did not. So there's a saying that I learned very early on in my legal career, and that is that you could pay um, $600 for advice from an old lawyer, or you could pay $100 for better advice from a young lawyer. Um, and I think that does still hold true. I noticed that uh, the older lawyers were not as sharp as I was when I was a young lawyer. I had a lot of very good ideas. Sometimes some of their wisdom would get them through. Sometimes they were just wrong about things. And there was a lot of value in the advice that I gave. I suspect now I'm in the old lawyer position and I, don't, don't have full perspective over it. Whereas every time I'm talking to you or any of the younger people in the office, which is everybody, I'm always thinking that, oh man, anyway, so let's have the facts.
Look at Paul out here just aging himself. Bad habit, I think. But our ridiculous
Oh,
driver.
you'll get there too. We all do. Yeah, actually, you're lucky if you do, I guess.
That's true. Very
Yep,
fortunate thing to be old, I think.
I think.
But we'll talk about Mr. Joshua Brown, who's a driver from Texas. He was driving a Tesla. We're getting a lot more of these stories, including one out of Coquitlam recently, where the driver was falling asleep behind the wheel and I think speeding.
Yeah, we
So there was
covered
that.
that one on the podcast. Yeah.
Um, a bit too close for home for me, but this one is from Texas. The driver, Mr. Brown, he had his full self drive initiated at the time. He was approaching a railroad crossing with the crossing gates already fully lowered and the warning lights were flashing. He admits to the New York Post that he did see the train coming, but he ended up relaxing in his seat and waited for his Tesla to
Oh.
continue driving. But
Well,
it
stop, I
didn't
assume.
yeah, it didn't
Waiting for
stop.
Tesla to do what it's supposed to do.
He decided to just punch the gas is what he called it, but, in a Tesla, there's no gas, so he accelerated, he barreled right through, the the gate on the other side. And, we've been talking a lot about dash cam footage, and his dash cam footage shows him just crashing through that other side of the gate, getting across just in the nick of time as this train is coming toward him. And then he slammed on the brakes on the other side. And then at the end, the Tesla message then came up with, autopilot disengaged. What happened?
Hmm.
Kind of the end of Mr. Brown's very lucky story of escape.
This is week 2 of near train collisions. As the ridiculous driver, last week it was a school bus driver, and the back of the school bus was clipped by the train, and it was terrifying watching like the video of the kids in the bus, seeing what's going on, right? School bus driver not giving enough clearance going over tracks with a train coming. This week we've got Tesla and a train. And it's the Tesla is the ridiculous driver. I don't know that the fellow behind the seat was, but like, why didn't he brake? Like,
Decided to relax and just let the Tesla take the wheel, so to speak.
I know, but he accelerates through in the end, right? To try and beat the train, or, to avoid
Mhm.
the Tesla train collision. But yes, Tesla fails to recognize um, crossing bar down and is planned on driving right through, and he made it speed through in order to survive by the sounds of it.
Mhm.
Anyway, ridiculous Tesla of the week. But I guess as we move toward more automated driving, more often we will see that the ridiculous driver of the week is actually the car.
Mhm. And I'll take this moment now to maybe pitch a podcast idea, is just you and Kyla sitting in a Waymo, maybe doing a podcast episode one day. I think that'd be really fun.
Well, I don't know that they're driverless now, that we see that there's operators in the Philippines
That's
that
true.
sitting in rooms driving, and none of those people have driver's licenses in San Francisco or wherever the heck they've got those cars driving around. It will be interesting to see. I just, the one thing that always comes to mind whenever I think of self-driving cars, is driving in snow.
Mhm.
And in BC, I just drove last weekend. I went and delivered a bunch of alcohol in the Okanagan. I drove as far east as Golden, and then back to Kamloops and down. And you can barely see any lines on the road. And I heard an interview recently on the radio. People were complaining about it. Maybe it wasn't on TikTok, not on the radio. I think it was. I was listening to it. I don't remember seeing it, but apparently we are no longer allowed to use the high quality reflective paint because it is prohibited by federal legislation as damaging to the environment. And so the paint that we're using on our roads doesn't make it through a winter, doesn't have that same reflective quality. And man, there are large sections of the road in this province that you cannot see any lines. Big sections of the Coquihalla, where they did a bunch of road work last year and didn't complete it until October. And you would have thought that there would have been a day that would have been warm enough that they could go paint lines. But there's large sections, like on the other side of the snow shed, no lines on the road at all. So how do you have a self-driving car or self-driving semi-trailer truck in circumstances where there's no detectable line on the road? And you have snow or the heavy rain that we get. Will they just pull over? You just stop and wait until spring?
Just hunker down and start hibernating. But, even I would be, as a human driving, I would be quite terrified to drive in those circumstances as well. Just no road lines.
Yeah. As I'm driving down the road, I'm, 2/3 of it is hope. Like 2/3 of it, not the town of Hope or the city of Hope. 2/3 of it is me hoping there's still a road where I've got my steering wheel pointed, where I've got my tires, the direction I'm traveling. Uh, Sometimes you can't tell, and sometimes you're just counting on the fact that there's light from another vehicle that illuminated ahead, so you know what's coming up. But when you can't see road lines, I have to think that this is a situation where um, there's a significant possibility of litigation um, if somebody's injured. And these ICBC limits on injuries might be something that is uh, unintentionally going to encourage the province to not worry about their obligation to ensure the roads are as safe as possible. So when we looked at this cap and basically essentially no moving to what is, as it plays out, a no fault system, because all you get is, a moderate payout, and you never get your actual injuries necessarily paid for, and there's really no incentive for the government to find fault to anybody now, because they're just paying you whatever your rehab, and a tiny bit for your lost work. What is the motivation for the province to get out there and paint those lines when they know they're not going to get sued? Just a thought
Mhm.
for another podcast. So we've got the Waymo subject of me and Kyla doing a podcast, or thought of that, and then we've got another topic to cover. Anyway, thank you so much for joining me, and thanks everybody. We will be back next week, and I'm sure Kyla will be with us once again when she's got the time.
Great return.
Tune in for another exciting episode of Driving Law with the return of Kyla Lee. And if you have been, if you were alleged to have been rear-ended somebody where you're impaired, and they say that you caused bodily harm, or you paid a ticket that, or are about to pay a ticket, give us a call at 604-685-8889 and find us at vancouvercriminallaw.com.